presentation. Okay. Well, we are really excited that Trent could join us today. I think he's probably getting sick of seeing Beatrice and I because he was joining us the last 2 weeks with our academy. So, but we are so grateful that he could take time out of his very busy schedule to be with us. Trent, if you're not familiar with who he is, definitely get to know him. He's amazing. He is with the Utah Prosecution Council and is their trauma-informed educator for law enforcement and prosecution. He has an amazing bio, so I would check it out, and he's going to introduce himself a little bit as well, and I'll just turn the time over to you, Trent. Is your sound working okay? Sorry.
I think I froze up for a second. Can y'all hear me okay?
Yeah, we can hear you now. Yeah. You're freezing just a tiny bit, but.
Can y'all hear me okay?
We can hear you now. Yeah.
Okay. By the way, very, very pleased and pleasure to be here with y'all and Vicky and Beatrice. I will never get sick of you. Very much enjoy your company and love getting to work, especially with our advocates. I'm so glad to see so many of you here. I want to start, if I can, I'm curious about the crowd we had. Anyone out there have less than a year of experience in being an advocate? We have nothing but veterans.
And you guys can use the little react emojis. But yeah.
3 new ones at the refuge. That's great. Anyone else? Awesome. Savannah, Carla, welcome back. Good to have you. How about on the opposite end? Anyone here have more than 20 years of advocacy experience? Okay, Lindsay was really quick to clarify. She's on the under a year end. Vicky, we've got 18 years getting there. Okay, so we actually do have quite a few new people. Colleen, 21 years. That's awesome. I thought I saw some vets on here. Good. Well, we've got a broad range, so I'm going to try and present in a way that hopefully benefits both ends. But this is going to be very, very interactive if we can help it. I'm going to go ahead and share my screen. Can everybody see that okay?
Yeah.
Okay, if I have my chat box up, y'all can't see that, right?
Nope.
Perfect. Okay, we are going to talk about the case that has been hopefully at least alluded to. Hopefully y'all are prepared. This is the state of Utah against Derek Shepard, prosecutor style. We're going to get a little bit of insight into prosecutors and what we do and why we do what we do. Just a little bit of background about me. There may be a handful of you that know me, but perhaps there's a lot that don't. So I was in the United States Navy Reserve for 11 years as a translator. As you can probably clearly tell by my pale complexion and red hair, I speak Thai and Laotian. I spent 11 years there while also being in law enforcement. So I started my law enforcement career as a dispatcher with VEC, which if those of you who don't know, that's a predominant dispatching agency in Salt Lake County. From there, I went to West Valley. Do we have anyone here from West Valley? There we go. I saw
Natalie and I are from West Valley.
Raised the roof. I've been presenting at UPA and there are 0 people there from West Valley. And I was like, it's probably fair because West Valley has a little bit of work to do. There's a lot going on in West Valley. But loved my time there. I had the opportunity to be a patrol officer, was a SWAT officer for 4 out of my 5 years there, and was also a detective. Most of my cases were special victims cases, so I had a lot of DV and sex assault exposure. From there, I went to law school at the University of Alabama. Roll Tide, thank you. I was a prosecutor in Birmingham during law school. And after graduating, I moved to Texas. I was in Houston for a year and then was in Dallas for 5. I've had jury trials and everything from seatbelt cases to murder. You heard me correctly. In Texas, you can have a jury trial on a seatbelt case. And I've nailed that sucker for the record. I was also the chief of a family violence court in Texas. They had domestic violence specific courts. So if you picked up a DV charge, it would get funneled to that court. That way, judges in the know, prosecutors in the know, probation officers, clerks, everyone's trained in how DV works. Really good idea. Hoping it catches on here in Utah. There's a couple of district courts that are doing it on a trial basis and would love to see it catch on. I also was in public integrity and ultimately came back to Salt Lake County, where I handled special victims cases. And just in October of last year, this position opened up. I am the sex assault domestic violence resource prosecutor for the state of Utah on the Utah Prosecution Council. I'm the SAD verb, and I'm working really hard to get that acronym changed because I do not want to be a sad verb. It sounds depressing. But I do a lot of training. I train police officers, prosecutors, advocates, love doing trauma-informed training and call back on my police experience. Have had the opportunity to train a lot of officers across the state. If you are in an agency that you feel like really needs that, please reach out because I travel everywhere. I love doing it, and generally it's been really well received. Let's go ahead and dive in and start talking about the first thing I want to focus on for today, that being the charging decision. Before we get into some details, I wanted to talk first the mechanics of it, right? Perfects an arrest on that exact day. Typically what will happen if it's a felony, that person, am I cutting out for everybody?
It's sounding okay now. We're going to turn our cameras off just to help too. So
I'm so sorry. Are we good now?
yeah, you're good.
Okay. So typically, if I have my officer who has responded, perfected an arrest, it's a felony case. Typically, there's not much more investigation to do. They may close out the case, but if it's a bigger agency, after that, there's oftentimes still a detective review to make sure everything's sewn up. After that, the detective a lot of times will send a packet of information to a prosecutor's office. For our largest agencies, they're going to have a screening division. So if you live in Salt Lake County, if you are in Utah County, it's typically not the prosecutor who is prosecuting the case that reviews it initially and makes the decision on which cases to charge. So this may vary from jurisdiction to jurisdiction. If you're in a smaller city, you may have the officer who is also the detective who sends it to the prosecutor who both screens it and prosecutes it. If you are in a larger city, there's likely going to be several more levels of hierarchy that it goes through. You're going to have your patrol officer. Sometimes that may even go through a sergeant. Beyond that, then it may go through a detective. Then it goes through the screening division. And that's the prosecutor who will make the decision of which charges to file. In Utah, we kick off our criminal cases via information. This is different from state to state. There are grand jury states, and grand juries provide or hand down indictments if they decide there's probable cause on a case. To kick them off here in Utah, we do not have grand juries. We start with a prosecutor filing an information. I wanted you all to take a look at one as we talk about this, just to keep this in your mind. So just to make you all feel okay, this is a public document. Here we have an information filed against a defendant on a murder case. There is a statute that lays out exactly what needs to be in this information. It's got to have the defendant's name, date of birth, and address. In an ideal world, we also want their SO number. If they have been through their initial appearance, the prosecutor also needs to list the bail amount as well as the status of the defendant, whether or not they're in jail. You will also typically see in the top left corner who is prosecuting the case. If it's a large office, you've got the district attorney always listed up top. It doesn't mean he's the one handling the case. And then you've got your prosecutor who screened the case listed below that. It's a smaller agency. If you just have one or two prosecutors, it's likely just going to have that prosecutor's name. I mentioned previously, if it's a Class A or if it's a felony, we're going to have a statement of facts. But regardless of which level it is, Class B, Class A, felony, you're going to have a charge. On this specific one is murder. Domestic violence in parentheses. All of this is designed to give the defendant notice of what we're charging them with. So it's specifically going to list out the elements of murder. We've added the domestic violence tag. You can see up top it says the detective who is about to swear to a statement. Here's the second page, the witnesses, and then you have the detective's statement. On a Class A or a felony, we have to have a probable cause statement or a statement of facts that amounts to probable cause. Class B, Class C, it's not required. On the last page, going to have ultimately whoever the deputy district attorney is, city attorney, or county attorney that signs off swearing to the information that's provided. So let's talk about things we want to consider when we're charging someone. And I'd actually like to ask you guys, I gave you a little sneak peek of my thoughts, but when we're making a charging decision, I want to know what you guys think we should be considering. Go ahead and use the chat box, type them in. We'll talk about them as we go. If I am looking at a set of facts, what should I be considering as I decide which charges to bring against them? And Jennifer, spot on. Typically, the first thing I'm going to consider is which facts line up to which elements of which crime. Carla, what led to the crime? I like that. So I'm going to want to know lead up. Savannah pointed out previous convictions. So I want to know what their criminal history is. Each charge, we might be able to enhance it. Injuries are really important to consider because I may have a different charge altogether depending on the injury, but also I may not want to undercharge something if we have a really serious know what the injuries were, right? If I get a report from an agency and it lays out that someone was hurt, but I don't know how bad, that may be the difference between an aggravated assault, a felony, and a misdemeanor, just your assault bodily injury, right? What else? Anything? Yeah, if the charges are appropriate, as well as whether or not we have enough evidence to charge. So you guys are hitting on a lot of the things that I mentioned. Earlier, we had somebody talk about how we have to look at the elements of the crime. It's really, really important that we have every element. If I'm missing one, I cannot bring that case. So if I have, for an easy example, if there was a murder committed in Idaho, Chad Daybell, atrocious murders. I evaluate the case, I look at it, I'm like, God, I absolutely think this is murder. It's heinous, but I don't have jurisdiction, which is an element we need to have, right? I can't bring that case because it didn't happen. And I'm also going to look at the severity of the case. Jennifer mentioned injuries. That's really important. One thing that I don't know that we really hit on, but when we're talking about domestic violence, when we're talking about sex assault, I'm really going to want to know about the level and ability of my victims and witnesses to participate. I may look at a case and think, I really know an aggravated assault happened here. However, I may not get the participation of certain witnesses, or I know from this report, they are telling me they're not going to participate in prosecution. If I think my case is a long shot, even if they're participating, that may be something I take into account. We talked about criminal history of the defendant. There may also be extenuating circumstances. Maybe between the time that the officer responded and the time that I received the report, there was already an attorney hired who provides information to the state about what the defendant was going through at the time, or about their mental health history, about their drug addiction that perhaps maybe changes the level of charge we want to bring. So I want to look at this case in particular. State of Utah versus Derek Shepard. You all tell me, what charges should we even kick around? What charges should we consider based on the facts that we have? All right, Savannah's kicking us off. DV in the presence of a child. Definitely need to consider that, right? What else? We're going to go through each of these in a little bit more detail, but I just want to kick off by talking about which charges we should even consider. Kristen, aggravated assault for the strangulation. I love it. Right on the money. What else? Thank you, Vicky. I definitely want to make sure y'all can reference this case. This is a really good case to workshop so that you can get into the mind of a prosecutor. I'm going to tell you about what we consider, about each of the elements related to these, and about what could potentially change our mind as we go along this road. Unlawful detention. I like that. What else? We got deviant presence, aggravated assault, unlawful detention, anything else y'all can see. All right. Karina mentioned the kids were present. So we've got our DV in the presence. Jamie mentioned criminal mischief or property damage. We call that criminal mischief for say the shift to property damage. We'll talk a little bit more about that as we go. Anything else y'all think we should consider? Let me go through the ones I was looking at. We talked about aggravated assault, strangulation, property damage, or criminal mischief. So in the past, Karina, We always called damage to property criminal mischief. Just within the last couple of years, the legislature updated the statute name for causing damage to property, just calling it property damage. A lot of times we'd end up getting in court and get into a jury trial and say criminal mischief, and people expected something very, very different. So now we're calling it property. I like considering that. I like considering unlawful detention too. This is one that nobody mentioned, that honestly, a lot of times in strangulation type cases, there are lay people or experts in the field that bring up, if someone's cutting off someone's air supply, that could kill them. So I actually do want to kind of go over that. These are the ones we're going to center on. I definitely think child endangerment and unlawful detention would be worth a discussion. For today, we're going to evaluate these ones I have listed here. Let's talk first about attempted murder. I'm going to go through just the elements that would be required for this particular case. So first, we have to have a substantial step toward the commission of that particular crime. So a substantial step toward murder. And show the person intends to commit the crime. Let me ask you guys, where do you think we would have a hard time, or would we have a hard time with any of these? So I have the elements of murder listed at the bottom. You have to intentionally or knowingly cause someone's death. For it to be an attempt, you have to take a substantial step toward that. But I also have to show that their end game is to commit that crime. Their end game is to intentionally or knowingly cause the death. Where do y'all think we might struggle on this case if we were trying to prove attempted murder? And I don't expect legalese answers. I just honestly want to know, even if it's your Dateline viewing perspective of this, would love to hear it. Kristen says intent. So that last part, intends to commit. You're right on the money. That's where we're going to struggle. A lot of times on these types of cases, you might even have experts that would get up and say, well, in strangulation, it doesn't, oftentimes it's used as a scare tactic. It's used as coercive control. This is not something that people who commit strangulation and death. So we know that if someone strangles someone, ultimately the lethality of that goes up several times over. I'm pretty sure y'all have talked about that today. But saying that that's what they intended to do is going to be a hurdle. To get our jury beyond a reasonable doubt for that is tough. Now, aggravated assault. Someone earlier mentioned we're doing the strangulation portion of aggravated assault. Do any of y'all know what that would require us to prove, what the elements of aggravated assault
We couldn't hear your question very well, Trent. Sorry, cut out.
So sorry. So anyone know the elements of aggravated assault strangulation? What am I going to have to prove in order to try and get a conviction on this charge? Impeding circulation, impacting normal breathing, obstructing airway. Y'all are experts. So first of all, we've got our intent. We've got to show it was intentionally or knowingly. So it can't be accidental. I have a hard time thinking it's ever going to be accidental. Like, The husband's going to trip and end up having his hand land on his wife's throat and squeeze. But we have to show it was intentional or knowingly, not accidental. We also have to show that they're impeding their breath. Y'all hit on that, many of you. Here's what's applicable under our set of facts that we have. So there are other ways to impede someone's breath or circulation. But for the facts we have, by applying pressure to the neck. And one last one, likely to produce unconsciousness. Just kidding. This was an element of aggravated assault strangulation until this most recent legislative session. So glad we got rid of this. This was really, really difficult in court. So we had some judges that were out there at preliminary hearings, and if we didn't have an expert get up and testify that the pressure applied was likely to produce unconsciousness, they wouldn't even let us get past preliminary hearing. And then we had other judges out there that once we got to trial, they wouldn't let our expert testify about how much pressure it takes. And in that case, we talked to our juries afterward, and they'd be like, you know what? I don't even know what that means. I have no idea how much pressure it takes to cause someone to likely produce unconsciousness. So that language is gone. In theory, this should make us a lot more effective in our strangulation cases. Let's talk about property damage. So this is our criminal mischief / property damage charge. Here's our elements for that. Intention defaces property of another. What's the property we have destroyed here or damaged here in our case facts? We got a broken plate, right, Savannah? Now, I'm going to tell you guys what is, you probably already know, but it's a hot button topic. This is really contentious among defense attorneys and prosecutors, even among some legislators, as we saw in this last legislative session when talking about DV cases. Property of another. Do we know whose property this plate is in this case? Lindsay says it's mutual property. So if we have a marriage and this is a plate that's inside the house, we're going to view this as mutual or community property. In other words, property owned by both the husband and the wife, right? Do y'all think that qualifies as property of another? Lindsay says she's in. Savannah, it's a hard one. So there's actually a definition in the code. And Michelle, that's good input. The code says property of another includes property where anyone other than the actor has a possessory or proprietary interest in any portion of the property. So the way I read this, and I can tell you the way 95% of prosecutors read this, if it is community property, if the victim was allowed to borrow it, if the victim has any ownership stake in that property, even if the defendant has a larger or better claim to the property, that's still property of another to me. I need to qualify that because I know I have discussed this issue with a prosecutor or two who see this differently. Quite frankly, speaking honestly, I think it's just because they don't like it. They say things like, well, that would mean that if I broke my own key to my car or my golf club while arguing with my wife, that's criminal mischief. And I'm like, yeah, and it's a problem. That's I think that's property damage. If they have a property interest, and I think it's something we want to get rid of, right? It's not just that they're damaging property, it's a show of force. It's them saying, hey, you're next. Watch what I do to this plate, watch what I do with it to this wall, and fall in line or else. So that's how I interpret this. Most courts see it the same way. Most prosecutors see it the same way. However, this is sometimes a fight. So keep that in mind, but good analysis by all of you. Now, DV in the presence. We talked about this. Commits an act of domestic violence in the presence of a child. First of all, how many counts do y'all think we have? Or do we have multiple counts? Is this just since there were kids there, we've got a charge of DV in the presence? Okay, before we move on to this, I want to answer, and y'all that are chipping in are 100% correct. So Savannah asked, would the victim have to make a claim of ownership? Would she have to testify and prove that she had some sort of use for the plate, or is that assumed due to marriage? I can tell you that from my experience, I would assume if the plate is in the home and they are married, I am going to 100% argue that that is a piece of property that the victim has a possessory interest in, and thus that is property damage under the legal definition. But very good question. Y'all are right. I'm going to go 3 counts, 1 for each kid, right? And rightfully so, because the effects are going to be there and maybe even different for each kid. Next question, though. What if they were in another room? Or what if they were asleep? In this case, do we have any of that? And Savannah, you said it still counts. Why would you say it still counts? Cheryl, money. Cheryl's a walking Utah code. If the child may see or hear. So if I'm the prosecutor in that case, if there's a kid in the house, as long as it's not some stowaway that the defendant had no clue was in the house, I'm absolutely bringing that. If you have a child and they're in a bedroom, they 100%. Move on to the next phase. I think y'all have grasped the decision. Y'all even brought up a couple more charges we might consider and each of the factors associated with that. What do you think we consider in plea bargaining? Or even what should we consider? What factors should we look at as we're determining our plea offer? We've got some really good input. What they would likely be found guilty or not guilty of, 100%. Prior DV charges or criminal history, whether or not we could get concurrent or consecutive sentences, victim input, or Kristen's looking at the specifics of it. Dismissing one of the particular charges is something we might consider. victim input, well-being of the children. To show you guys with what Megan was talking about, I'm going to look at the strength of the case. How likely am I to secure a conviction on each of those different charges? I'm also once again going to look at my victim and witness participation. Once I get to plea bargaining, oftentimes this is months after the case has occurred. At that point, because of the way domestic violence works, I might no longer have victim participation that I had earlier. That may change my perspective on an appropriate plea offer, right? My strength of the case may also be looking at what can I get in if my victim doesn't testify. May look at what has defense presented me with. And this is one that is kind of hard to swallow sometimes, but I may have a DV case that I look at and recognize is a real problem. I feel like my evidence is solid, but then my defense attorney brings me a series of communications from my victim or survivor that I may know exactly why they did what they did, but I may also know a jury's going to hear that and they may now have a hard time convicting on certain pieces of this charge. I may also look at the defendant. If I have a particular type of case, this is probably a much bigger factor in other types of cases. If I have, let's say, a drug case and my defendant immediately checked into therapy after getting out of jail, I'm going to take that into consideration. Criminal history. Earlier, Jamie mentioned prior DV charges. Definitely something I'm going to consider. Public perception. I don't mean it because I care about what the public thinks about what I do. I mean it because I need to know how this is going to play out in a jury trial, which brings me to another consideration is I need to look at my risk. I'm going to talk about it in more detail. So victims not able to participate. How do you all think that would affect our case, considering the facts we have on State of Utah versus Derek Shepard? What if my victim calls and says, you know what, I'm done. I can't do this. I'm just not going to show up and testify. How do you all think that affects my case? Do I still have a case? Jamie says, plea it out, don't dismiss. What if in that circumstance, my victim says, you know what, I'm not going to show up. I'm not going to be there. And I tell the defense attorney I still want to plea, and he says, nope, I know she ain't showing up to testify. Megan says, no crime without a victim. Jennifer says, do I have other witnesses that can corroborate? Very, very interesting line of thought. Let's look at this case. We've got an 8-year-old daughter that ran to the neighbors, right? If mom called me and said, I'm not going to testify, what do y'all think about using the 8-year-old daughter? Yeah, this is where okay. This is honestly where rubber meets the road with these types of cases. we have a lot of, if I'm the prosecutor on this case, and I know mom's not going to pay, if I send it to the I have to send it to the person of the child, right? So then I send it to mom, try and get mom held in contempt. Really unlikely that I get to that point personally. I do not want to issue material witness warrants unless it's an absolute last resort. A lot of people are mentioning the CJC, but keep this in mind. If a CJC was done, I can use that at prelim. I can get past that hurdle. But if I'm going to use it at trial, I still need that 8-year-old there because the defense attorney needs to be able to cross-examine her. The way the rule is written, having a CJC isn't simply a free pass to get it in a trial. I'm still going to have to be able to have the child present and available for cross-examination in order to get the CJC interview in a trial. So I'm going to look at whether or not I can get the evidence with material witness warrants for my victim, unless it's a last resort, right? Okay, you know what? I think we've got pretty dang good evidence. Even I think I can use in this particular case that we have, even if my witnesses don't show up. How am I going to be able to prove my elements? I think I saw someone mention earlier. Officer testimony. What do you think? What statements can my officer talk about? So a police report, I'm not going to be able to enter that, but my neighbor, I may be able to get in some statements from her. She heard fighting, right? I also have the statement given by the 8-year-old to the neighbor. I'm going to tell y'all that the general rule is I can't get in a statement of somebody if that statement was made out of court. But if it's an excited utterance, if it is a present sense impression, that can overcome hearsay. So there's a few statements here that are given by the victim to the officer. When the officer comes back the second time, he talks about how she's still crying, which is going to lay my foundation for her being excited. I believe the police report talks about the 8-year-old's emotions as she was calling the police, as she was talking to the neighbor. Savannah's also correct. I'm going to get in the observed injuries like Kristen's talking about. I'm going to be able to get in what the officer saw that corroborates that were excited utterance or present sense impression. How about, this is often the tough thing to do. I still need somebody to stand up in court and say, that defendant right there is the cohabitant here. Meaning we've heard all this about the victim, but that guy over there, that's the one who caused these injuries, and he is married to her. How do y'all think I'm going to be able to get that specific information in? Because if I remember right, the victim doesn't give an excited utterance that we could get in about their relationship, about the fact that that dude sitting in court is her husband. The 8-year-old is not going to be able to, her excited utterance or present sense impression is not going to be able to do that either. Ruthie, on the money again. Admissions from the defendant. So the defendant corroborates some of the story. He corroborates that there was an argument. He corroborates that those are their children. So with him admitting that he has children with the victim, I think that's enough for us to be able to get the elements we need for DV tag and DV in the presence of children. So this is always going to be my first step on these cases. Now let's pretend I don't have excited utterances. I don't have present sense impression. I'm probably not going to have a case if I don't have victim participation. And ethically, I cannot proceed on a case without that. I may lose my law license if I know my victim's not going to show up, but I keep trying to press it to trial. So it's really tough for me. I'm sure it's tough for y'all to watch on the cases that were like, I know a crime was committed. I know this is a bad dude, but if I know I no longer have probably DV case, I'm looking at it any angle I can to try and get evidence in if my victim is no longer able to participate. This is one more thing I wanted to make sure y'all are aware of. This is the ultimate wild card in our cases. We have our judges, and I love them to death. The judges here in Utah, I can tell you from my experience, most of them work very hard. Most of them are very, very smart, but they may see case law differently than I do. They may know that they want this case to go away because of a personal bias. And there may be nothing I can do about that. I may evaluate the case and say, I've got all of these excited utterances. I've got pictures of injuries to corroborate those excited utterances. I've got a child and a victim making statements. And my judge may say, no, Mr. Dressen, I see that differently. If I know how he views those things, I may not want to drag everybody through that. So that may affect my charging decision. It may affect y'all are in a situation and you see something happen to a case and you really want to know why. I would absolutely ask your prosecutor because there may be some other factors at play that you don't know about. I do not want to drag my victim through a trial, nor do I want to drag my victim and witnesses through knowing a trial is happening if I know what the end result's going to be and it's not going to be one that I like or they like. Here's another one that may affect the plea bargain or plea agreement. The defendant, criminal history. We've already talked about this quite a bit. This does change things, right? If he's got prior DV charges, it's going to change the level of offense. It's also very much going to change my perspective and what I'm going to offer. If he's been proactive in getting therapy, showing a lot of remorse, if it was an instance where there's no history of any sort of violence outside of property damage, and he's gone through therapy, and the victim says they see a change, that might affect my plea offer, right? And also, last but not least, is the risk. So my victim may ultimately decide not to participate. She may have been on board, able to bargain through a preliminary hearing, and I still know that Salt Lake County has some rough jurors. It's a rough crowd. I'm going to get 12 essentially, or 8 essentially random people from the county, and I may get a rough draw. My judge, who I think I know, may end up showing up to trial and ruling in a way that I did not expect. There is always risk in every trial. I have had cases I thought were slam dunks that the judge thought was a slam dunk. The defense attorney knew they were going to lose, and they came back not guilty. There is risk in every single trial, regardless of the amount of evidence. So we have to take that into account. I may get a case and say, I can prove every single charge in this, but my plea offer may not be, you're going to have to plead to every single charge in this because I have to account for risk for each of these reasons mentioned. So now we're going to cue some plea offers. Vicky, is this where you step in? We want to do a poll and see what people think.
Let me get it going.
So we've got our two options here. If I were to offer third-degree felony aggravated assault, got to take that. I'll dismiss everything else. Or Class A misdemeanor and DV in presence, dismiss remaining counts. Which one do you think the defendant would take if I offered these?
We're getting some good responses. It's about a third of the way through.
I think it required you to also put in the sentencing option as well.
Yeah, sorry, I did them combined. I realized that that might confuse people.
But I can tell this is a talented group. I'm sure they can decide both of those things right now.
That's right. Give it just another minute and then we'll close it.
And maybe even as we're waiting for that, those of you who have already decided, if you decided option one, why? What's your reasoning that you think a defendant would take that over option two? Or even option two. If you picked option two, put a 2 in the chat box, and next to the 2, put your reasoning.
So those popped up if you can see the result.
Did see. Vast majority of people said charge amended down to Class A, DV in presence.
Yep. And the sentencing option the judge would choose is the 36 months of probation.
Don't want the felony on their record as a common response. I'm going to go through essentially pros and cons of each. I think you guys are probably on the right track. I'm going to tell you what may be considered if you go for option one and dismiss remaining counts. Pros on our end. We got a conviction, right? We've got prison time on the table. So even if this person ends up on probation, prison time is an option if they end up reoffending, committing a new charge. This also, because of the nature of the offense, is going to restrict our access to firearms. It also gives us protective order options. Cons. If I go to defense attorney and say, I want him to plead to count 1, the third-degree felony, and I'll dismiss everything else. They may say, you know what, this judge, even if he's convicted of everything at trial, is going to run everything concurrently. So that means nothing to me. If he pleads to a third-degree felony, he's going to get the exact same sentence as if we went to trial. So I'm not taking that. He may then try and bargain with something else, like there was no DV tag mentioned if he took that. He may say, I saw no DV tag. Are you going to keep that off if he pleads to that? Oftentimes, a DV tag is used as a bartering chip. A lot of people don't like that. I do, that in select circumstances, if I look at the case and I think, you know what, there's a really good chance I get nothing if we go to trial, I need something. I need a conviction. I need to start building a history on this guy. I think he's a bad dude, and I need something. Second option, a lot of you chose that for a lot of the reasons I said, right? The pros for us. We've got a clear indication of children present. If anyone looks at his criminal history, they can see he did that in front of a child. I think that's good. We kept the DV tags. We've got a restriction to firearms. We also have multiple counts. Higher likelihood of reaching plea agreements since we've got an amended charge to a Class A. Cons, y'all mentioned this. He's avoiding prison. Severity's downplayed. This was a really serious thing. We understand how bad strangulation is. If I take it to a Class A, this guy's going to go the rest of his life downplaying this. I pushed her. We just got into an argument. It was no big deal, but I had to take it because I was risking prison time, right? All of this goes into our mindset as we're going through these types of cases. There are so many factors at play. Ultimately, I do hope you keep in mind, as much as I want to serve and take victims' input into account, it is one factor for us. We rep the community at large. That may not always match up with what my victim wants, although oftentimes it does. I appreciate you guys' attention throughout all this. Appreciate you guys trying to better yourselves by being here today. And I appreciate you all doing what you do every day. I know you're underpaid. I know you're undervalued and often unthanked. You have my thanks. Thank you so much for doing what you do. Thank you so much for being here today. If you need anything, my contact information is listed. Questions. How long does it take to screen cases for charges? That is a loaded question. It's going to differ from jurisdiction to jurisdiction. If you're in a larger county that has a screening team, oftentimes there is a backlog. If it's someone in custody, that's likely going to be faster. If it's a smaller county, smaller city, that's likely only going to take a day or two. But what I would say on that note is make sure if you have a question about where the case is at, call. Find out who the prosecutor is screening, ask for a timeline, say you want to update a victim. Any other questions?
Yeah, great question. Okay. Well, thank you so much, Trent. We really appreciate, love this perspective. I think it's so valuable, just to bring in all the different factors that the prosecutors have to consider and look at, and when they're considering and charging on a case, filing on a case, or having the case either go to trial or not go to trial. And then there's a lot of those factors that come into play, whether the defendant is going to agree to those different pleas and why we would maybe want to offer a different thing. So hopefully that was helpful for you guys to kind of see that different perspective, but we really do appreciate your time, Trent. Always a pleasure to have you. So thank you so much.
Thank you. Y'all take care.
Okay, thank you. We appreciate it. Okay, I had to stop.